no video.
Oh, it says there's no audio. Oh, it's too late. Hi, everyone. We're just getting started, so we'll give everyone a few more minutes to log in, and we'll get started in just a couple minutes, so hang tight. Thanks. Hi, everyone. We'll just give folks another minute or two to log in, and then we'll get started. Thank you. All right. Hi, everybody. Thank you for joining us today. We're going to talk about some of the rep registration and other requirements that are out there. We'll do a little bit of background and then dive into some of the new and exciting details. A couple things just administratively before we really begin. First, if you would like a copy of the slides, you can certainly let us know. We're happy to send them out after the webinar. Second, I believe everyone is on mute, and so if you have questions, we're happy to try and answer questions either at the end of the webinar or we'll get back to you individually. There's a little questions box as part of the GoToWebinar dashboard on the right-hand side or wherever you have it docked on your screen, and if you type in a question there, we'll see them, and like I said, we'll try to do as much as we can today, and if we don't get to your question in particular, we'll respond directly to you after the fact. Lastly, I just wanted to mention that we are hoping to make these webinars a more regular event. So today we'll consider it the first of hopefully many, and we're going to try and do maybe every other month or something along those lines. And so I'll ask that if anyone has any suggestions or requests for other topics, whether on the transparency front or otherwise, we're all ears, so you can enter those in the little questions block as well, and we'll take note of those so that as we move forward and come up with our next webinar sessions, we can hopefully speak to some things that are particularly of interest to all of you. All right, so without further ado, this is Christy Bradshaw. I should have said that from the beginning. I am a Vice President with Porzio Life Sciences. I am also an attorney, as you can see, so if you are not an attorney, please don't hold it against us. We are happy to talk through this interesting topic today. We spend a lot of time in the transparency space, but Porzio does a lot of work in a lot of other areas. on the compliance front related to distribution and licensure and sampling requirements and promotional review and international limitations and requirements. So as we go forward and like I said, if you have other ideas for topics, any of those areas are fair game. And I'm joined with a colleague today, and I'll let her introduce herself.
Hello, everyone. My name is Ingrid Pelzer, and I am a senior manager here at Pharmaceutical Life Sciences. And I am very happy to be sitting with Chrissy and discussing this area that's been pretty hot and pretty robust over the last year, especially as it comes to Chicago and Nevada. But we are happy to get started and happy to answer any questions that you may have.
All right, let's see if I can do this right. Okay. So for today's webinar, a couple topics. We're going to talk about some background information. We wanted to sort of set the stage as to some of the things that are already in existence, have been around for a while, that apply to your reps that are in the field. And part of that is just to say that not all of these requirements on the Chicago and Nevada front are new. So hopefully that's helpful as you talk with them about some of the newer laws and ordinances out there. We're going to talk about some, as I said, some current requirements, so DC, some of the state lobbying requirements, and then some of the medical facility requirements, just as examples. And then we'll dig into the Chicago registration and reporting requirements, and then the Nevada requirement, which is still new, but will be kind of the next big one, we think. All right, step one, what is currently out there? So we'll move through DC somewhat quickly, because for a lot of you it's probably not news, not new information, but DC put in place almost 10 years ago, which is amazing to say, a detailer requirement that says that any pharmaceutical detailers, will define that, that are active in DC must get a license before engaging in that detailer behavior. Okay, so of course it begs the question, what in fact is pharmaceutical detailing? And so detailing is the practice by a representative of communicating, so there has to be some kind of communication in person, so we're talking about activity that takes place in DC, with certain folks, healthcare professionals and their staff, for the purpose of selling, providing information about, or in any way promoting a pharmaceutical product. So it's pretty broad. There are some limitations, some exemptions. So folks that are on the veterinary side, they're not included in the requirements. There's a specific provision that says that health professionals who are participating in a conference, including something related to a local audience, where they're speaking or presenting on an area of their expertise, don't have to register, aren't considered pharmaceutical detailers. So that's something that a lot of us had kind of hoped for, and we're happy to see when they added that in. And then you see the last bullet here. This is relatively new within the last year or so. I think that they clarified, I'll say, or added this specific limitation that for folks that act in DC, the detail in DC for fewer than 30 days in a calendar year, they don't need to obtain a license. We'll mention, you see some little qualifiers here at the bottom, that this came via a temporary amendment that went into effect last year, but you see that it does have an expiration date later this year. And so we're hoping, we're expecting that there'll be permanent changes to the requirements that will limit the detailer requirements for that 30-day rule permanently, but we haven't seen that yet. So just something to be aware of, that one of the actions of DC would need to be to put that into place permanently for it to stick around beyond November 18th. Okay. Some activities that are exempt as well. You see, not surprisingly, I guess, that the detailer requirements don't apply to discussions about clinical work, investigational drugs, REMS programs, things like that. And that, of course, really goes to the fact that DC is striving to require licensure for folks who are marketing or promoting, which would be a separate conversation from any clinical or pre-commercial work. Another thing that's exempt is activities that take place at a conference, and a conference is a defined term. It means a large event that has 3 or more pharmaceutical companies presenting, and they can't be part of one entity, so it can't be the parent company and 2 subsidiaries. So the idea is that if you're at a large event in DC, you know, one of the major medical congresses, something like that, that you wouldn't be required to have somebody register solely to participate at that level. Okay. All right. So as a detailer, if you do have folks that are in fact detailers, they have to get licensed. They're supposed to be licensed before they engage in pharmaceutical detailing. They have a code of ethics that they have to comply with. They have educational requirements to get licensed and also to renew their license, and it is pretty intense, some would say, I suppose. There is a biannual renewal for DC, so it's every other year, each even-numbered year that the detailers have to renew their license. Something else just to mention is that if folks are licensed and leave your company or move to another area, move outside of DC, for example, they are theoretically supposed to let DC know that they will no longer be practicing as a detailer, so essentially let them know that they won't need their license any longer. Okay. Something that I'll mention with DC, just because it will be, I guess, somewhat relevant as we move forward and get to Chicago a little bit later, but one of the things in the DC requirements is an authority for the DC Board of Pharmacy to collect information about detailing. As many of you know already, DC has a disclosure obligation, so a lot of activity that happens in DC, meals and consulting fees and those kinds of things are being disclosed anyway. But specifically under the detailer law, there is an authority for the Board of Pharmacy to reach out to a detailer and require that they provide information about their detailing back to the Board of Pharmacy, and that would include information about the HCPs that they interacted with, the date of interactions, the location of a visit, whether any products were discussed, whether any samples were left behind, whether any educational materials were left behind, things like that. Again, as most of you probably know, DC has not, at least to my knowledge, acted on that. So they haven't requested that anybody provide that information, but it is part of the law and of the municipal regulations that implement the detailer law. So just something to be mindful of, like I said, as we move forward and talk about Chicago, because on the Chicago front, it's certainly something that they're talking about asking for, and some of the requirements are a bit challenging, which we'll get into. But DC does have some disclosure obligations, I'll say, or information collection obligations or authority, I'll say, in the municipal regulations. Okay? All right. So going past DC, we're going to dive into lobbying laws. We like to touch on these just because they're a little nuanced, and a lot of folks don't necessarily think about them when considering the obligations and limitations that are on our pharmaceutical representatives in the field. So I'll mention that most states, and in fact many local governments, have lobbying requirements, lobbying rules that require registration. Some of them require reporting as well. Many of them have restrictions on what's permitted, what kinds of payments you can make, what kinds of gifts and meals and all that good stuff you can have with government officials. But there are some jurisdictions that have specifically, in some fashion, talked about how those requirements apply in the pharma space. And we'll go through those today. There's only a few of them, but it's just something to be particularly aware of for the folks that are in this compliance area, because as you're training your reps, this is something good to be cognizant of in these particular jurisdictions. All right. So the first one that we have here is Colorado. There's a law, like I mentioned, lots of states have a law that requires lobbyists who have activities towards covered officials, government officials, and the like to register as a lobbyist and submit monthly reports. There is an advisory opinion in Colorado that specifically says that members of the Pharmaceutical and Therapeutics Committee are considered covered officials. So that's where we get the tie-in for Colorado. So to the extent that you have folks that are interacting with the members of that committee, whether it's to talk about a formulary status, it might be to provide free samples, this can be considered lobbying and would then require your detailer, your pharmaceutical rep, to register and then potentially submit disclosure statements if they have something to disclose. So the requirements specifically, they have to register online and they have an annual registration. And then, like we said, monthly disclosure reports that cumulatively for Colorado document the kinds of activities, the kinds of payments or transfers of value that have gone to these covered officials over the course of the year. Okay.
And now we're up to Connecticut. Connecticut, like Colorado, has a law, but then there is an advisory opinion that says that reps that are lobbying a member of the PNC committee to communicate with an executive branch official must register as lobbyists. And so in that opinion, it says that if a pharmaceutical company is communicating with members of the PNC committee in an effort to have their drug placed on the Connecticut preferred drug list, they must register as a client lobbyist. And then you have representatives who are compensated by the pharmaceutical companies. They must also register as a communicator lobbyist. And so this is one of those states where they're requiring not just the rep, but also the company to register as lobbyists, and also to submit reports regarding their lobbying activities. And it all stems from an advisory opinion that states that the pharmaceutical reps and companies are speaking with members of the executive branch. And usually in a lot of states, the executive branch officials are the ones who the lobbyists are speaking with. And so in this state, they have applied the lobbying laws to pharmaceutical companies and pharmaceutical representatives. Similarly, Kentucky has done the same thing. Kentucky has said that the Kentucky Executive Branch Ethics Commission has advised that pharmaceutical manufacturers and employees attempting to influence members of the P&T committee as one of their main employment purposes must register as an executive agency lobbyist. So the caveat here is that the influence must be one of the main employment purposes for that pharmaceutical representative. And if it is not, then the same advisory opinion says that you do not need to register. Again, there's a registration requirement, there are continuing education requirements, and there are disclosure requirements if you are lucky enough to be registered as a lobbyist in Kentucky. And Louisiana is one of the ones that we've been most familiar with, I think, for the longest period of time, because there, again, is an advisory opinion that states that pharmaceutical sales representatives who are interacting with members of the Medicaid PNC committee for the purpose of inclusion of their product on the pharmacopoeia or formulary must register as a lobbyist. Again, these lobbyists have to register, and they have to be registered before engaging in lobbying activities. This registration is renewable every year, and there are also monthly expenditure reporting that happens in Louisiana for those who are registered as lobbyists. So this reporting requirement is a little bit more, I guess, robust and
onerous,
but again, if you are registered as a lobbyist in Louisiana, this is what you must do. And then another popular one, Miami-Dade County, Florida. Another advisory opinion that says that pharmaceutical representatives must register as lobbyists if he or she approaches University of Miami doctors regarding the purchase of products and services. That will foreseeably be reviewed by the Public Health Trust Board of Trustees or a PHT board or committee. And again, these are all executive branch agencies. And typically, if you're lobbying an executive branch agency, then you must be registered as a lobbyist. And another advisory opinion has tied pharmaceutical representatives to the lobbying requirements. Like the others, you have to register within 5 business days of being retained as a lobbyist or before engaging in any lobbying activities, whichever comes first. And they are also required to renew their registration on an annual basis. That's Miami Dade. And as Chrissy alluded to earlier in the presentation, these representative registration requirements are not new. They're not novel. They're just they're something that reps have to do not just on the state and local level, but a lot of times, many times, if a pharmaceutical representative is visiting a medical facility, they typically need to be registered before engaging in any communication with doctors, staff, residents. They usually have to be registered by some sort of entity. So we have a few examples. The first is the University of Pennsylvania Health System. Pharmaceutical representatives may not only could they can only come into the facility by appointment only, but before they come, they have to be registered with the Department of Pharmacy Services. And usually the registration department that's charged with registering sales reps are looking for contact information for the rep and for their company. They're looking to see what type of drugs or what type of products they're looking to come in and speak to folks about. And there are some policies that are sort of mild, and by mild I mean you're asking for basic information. And then there are other policies where other facilities where they're looking for test results to make sure that you've had your TB test or that you've been properly immunized before you come into their facilities. So some are more substantial than others, but oftentimes you have to have some sort of, you have to be registered in order to access any of these health systems. And Pennsylvania, the University of Pennsylvania Health System is one of those. Another one, if you happen to be in the New York area like we are, New York Presbyterian Hospital requires vendor representatives in their companies to register prior to visiting the facility. And this is one of those facilities that says if anything has changed, you need to update it within 30 days of a significant change. Scheduling, appointments, all of those things don't happen unless you are registered. And there are plenty of facilities that have these requirements for sales representatives. And they can get a little difficult at times. And the interesting thing is that a lot of times you don't know that there is a requirement until the sales rep shows up at the facility attempting to speak to an HCP, and they are turned away because they have to go through either a credentialing agency or they have to go to another department. So it's good to know that these facilities are oftentimes requiring registration. Very good. All right, so we're going to jump into the new kids on the block. New kids on the block. Very appropriate for our era, so that's why we picked it. All right, so starting with Chicago, our new friend, we have a little timeline here, which you might be familiar with, but we present it just to show that this really moved relatively quickly, in my opinion. So last year, the mayor announced that they were going to put out a licensing requirement really specific to the opioid epidemic, right? So the idea that they wanted to know what interactions were happening so that they could try and track the conversations that were being had and the theoretical influence, right, that our industry is having
on the prescribers out there. And I'll mention too that just this past month, when the press release came out from Chicago announcing that everything was in effect, that they mentioned that again. So that still is in the forefront of the purpose and the motivator behind this requirement. So that was in October initially. In November, we had the proposed ordinance, and by the middle of November, the ordinance had been adopted within the city's rules. So that was very quick, obviously. The continued timeline, it was signed by the mayor by November 18th. So that part moved very quickly. After that, we waited a little bit to get some detail, I'll say, as to what this was going to look like, what the requirements were going to be. We received proposed rules in March. Frankly, most of us were probably swamped with federal and state reporting, so we probably didn't spend a lot of time on the proposed rules those couple of weeks, but did after that, certainly. And then in June, we had proposed rules that were adopted with some changes, and we'll talk about what some of those were. But again, it really moved pretty quickly, and the whole thing became effect on July 1st. So, you know, some of you that we work with had been saying, what's happening? You know, this rule is going to be effective July 1. We don't have any insights. We need to get our folks registered and licensed. We might have a reporting obligation. We don't know what to track. We don't know how to track it. So there were a lot of questions even into June. And since then, we have gotten a lot of information, a lot of detail. But I'll say, at least for myself, that a lot of questions still remain. And we'll see how a lot of this will shake out over the next couple months probably. So here are some key points. Just want to make sure everyone is on the same page. And I'll mention too that one of the reasons I went through DC a bit was so that you can see that there are some overlaps. Some of the language that we see in the Chicago ordinance and rules really does mirror the law and the regulations that we have from the District of Columbia. Not all of it, certainly, but some of it does. Some of it is an exact copy, and then some of it is similar. You can see some of the points are similar. So you can't have activity in Chicago without getting your license. The rule for Chicago is that if you are going to have fewer than 15 days of activity in Chicago in a year, you don't need to get the registration, to get the license. And you'll remember with DC that was 30 days. You see in red that the original regulations proposed that it would be 10 days. So we did go up from there. So we'll take that as a small victory. The commissioner had to give us rules, which they have. And the rules include an awful lot about education requirements, both to obtain your license and then to renew your license annually. And then you see there is, of course, I guess, a fee associated with the licensure. So it's $750 per representative per year. And similar to DC, originally this was going to be an every other year license, but they did change it in the final rule to be annual instead. So the cost is essentially the same, but instead of having to do it only every other year, your folks will have to be on top of this yearly. Okay. So here's some information, some additional information. The commissioner has to include some ethical standards. So we have a code of ethics in DC. We have a list of ethical standards in the Chicago rules as well. You see some of the points here. You can't have any deceptive practices. You can't use a title that misleads the folks that you're interacting with to the extent of who you are and what your role is, what your background is. And those are very similar. Those are in the DC rules as well. Okay. Just a couple more things, and this, of course, is what we'll talk about in a bit, but the requirements to disclose information periodically. And so this is what was in the ordinance. Limited information, a list of the healthcare professionals, how many times you talked with them, the location of the contact. You'll see here that it talks about the duration of the visit, and that's a big issue for a lot of the folks that we've talked to, and we'll talk more about that in a minute. The products promoted, whether any samples or materials were given, whether anything else of value was provided, and any compensation. So again, you see that some of that is similar to what we saw in DC, but this is certainly more. It's more expansive than what the DC rules allow for the department or the Board of Pharmacy to ask for from the reps. Okay. So we had the proposed rules adopted with a few amendments on June 1st. Who has to be licensed? So this is kind of clarifying who is subject to the rules. You have to have a license if you are doing business with a healthcare professional when you're both in the city of Chicago, and if you do that activity, that interacting, for more than 15 days in a calendar year, or I'm sorry, for 15 or more days, so 15 days would count. So it's narrow, you know, when you're thinking about who this applies to at your company. It's certainly not a lot of reps. It's a set number of reps. It might only be one or two. But for those folks that do have to register, it is a bit onerous, I'll say. So they have to apply online. I mentioned the fee. There is an online education course. That's part of the registration requirements, so they'll do that. They'll be prompted to do that little course when they go through the registration. Okay. So there are some exemptions. We talked about the 15 days, and then similar to DC, we have this limitation on conferences. So if they're attending a large conference with at least 3 or more pharmaceutical companies present that are not part of the same parent company, they don't need to register just for that activity. A reminder again that the activity has to take place in Chicago for both of the people. There are some nuances with that. The rules talk about if I am a rep and I am sitting in Chicago and I make a phone call to a Chicago healthcare professional, and I think that person is in Chicago at the time, but I'm not totally sure, but that person has their primary business practice within the city of Chicago, that would count as an activity that takes place in Chicago. If I, however, as a rep, am sitting in Grand Rapids, Michigan, and calling into this person in Chicago, that would not count as an activity taking place in Chicago. So there are some pretty specific nuances, I'll say, that we should all learn about. The challenge, I think, will be in how we handle those from a practical perspective. Can your SFA systems capture that information? Are you recording that call activity at that level now, or is that the kind of thing that you'll need to change your system to be able to record? So we put this up just to show you what the licensure little website looks like. There's a link. It's actually pretty robust. I think they did a pretty good job. It's through the City of Chicago's existing business license registration system. So just an added component there. Okay. So going into the reporting requirements a little bit more, you have to include the names of healthcare professionals, the location and the duration, the products, and then we're dropping some stuff off the bottom here, but what the products were, any materials that were given, any samples that were left, and then whether there's any compensation. The form is very long, so if you picture an Excel spreadsheet, it goes very far from left to right, and I did not include all of it, but the top little section here that you see is kind of midway through the form, and then the second piece here is a little farther to the right. But so the first section of the form, which I didn't include, is kind of standard information about the healthcare professional, his or her address, NPI numbers, things like that. But then it gets into, so the date of the interaction, which is fine, the location of the interaction, which is also a drop-down list, and in office, out of office, or telephonic or something like that. So it's those interactions, like I mentioned, where we might not be physically in the same place together, me and the HCP, but we are theoretically at least both in the city of Chicago. Then there's this duration of interaction field, which is something that we have not seen, right, for any of the other, the state reports or the federal report where we're reporting transfers of value specifically. But you see the interaction drop downs here, less than 15 minutes, 15 to 30 minutes, 30 minutes to 2 hours, 2 to 8 hours, 8 hours to 24 hours, and the guidance from Chicago has been that if the interaction is more than 24 hours, you should put it on 2 line items. You know, you would just have a second line item that would mirror the first, but have the next duration of time. So that's something different. It's new. It's a challenge, I think, to track. You know, are you going to change your SFA system to capture that information only for these folks that are interacting within the city of Chicago? It's obviously very, it's a small geographical area, and I imagine the reports will be pretty small in size, but it's something that you do need to capture to be able to comply with the rules. The next section goes into, you see it says pharmaceutical marketed or promoted, including adjusted names for new formulations. And the next column is were samples provided, and then if yes, the quantity of samples. So those 3 fields are copied 10 times. So you can identify up to 10 products that were discussed and samples that were left behind for any one interaction. So again, this is more than we've seen for the federal report and for Vermont, where we're identifying specific products, where in both of those cases we're only including up to 5, right? So again, if there are companies that where you might be discussing 6, 7, 8, 9, 10 different products, or leaving behind samples for more products than 5, you might need to adjust your systems to be able to track those additional 5 products potentially. Okay, jumping down to the next little section here, you see it says were pharmaceutical related materials given? If yes, what was the value of those materials, or any other transfers of value or compensation given to the HCP, yes or no, and then it goes on, value of consulting fees, value of compensation other than consulting fees, value of honoraria, value of gifts, et cetera, et cetera. So again, you see this is all one line item, which is very different than how we've done other reporting, right, where each line item would be a different transfer of value, a different product, that kind of thing. Whereas Chicago is basically saying for any particular interaction, there might be more than one product, there might be more than one sample, there might be more than one transfer of value, and those should be reported on one line item. Very challenging from a systematic perspective. It's definitely tweaking the reporting format, but it also might tweak how you capture your data. The other thing I'll mention is that this goes on to the right after gifts, after entertainment, to say food and beverage, travel and lodging, education, research, charitable contributions, royalty or license, ownership or investment interest, and grants. And for those of you that are involved with federal reporting, I imagine those values look very familiar to you. Okay. Something I'll point out just because I think it's interesting and I am unclear on what they're going for here. Chicago has the same limitation language that DC has, saying that pharmaceutical reps do not need to include interactions that relate to clinical trials, investigatory drugs, REMS programs, things like that. So, you know, you see here that one of the values for us to disclose would be the value of any research. And I'm not sure really in what scenario you would have a rep in Chicago talking to an HCP about research or providing a transfer of value related to research. So if anybody has an example of how that might happen, I'm all ears, because that's something that I kind of saw and said, I wonder what they're expecting to get there. Okay. The other thing that's really important to mention is that the reporting, specifically the disclosure requirements, only relate to a specific list of products, of drugs that Chicago is going to tell us, to provide to us. So this year, this July, when they put everything out on the website, you see what they said. They said any Schedule II medications, which makes sense because, as we talked about at the beginning, the idea here is to combat opioid abuse. So right now, the disclosure requirements only relate to those Schedule II drugs and interactions, payments that relate to the Schedule II products that your companies might have. So obviously, that's a pretty narrow list. Not all companies have a Schedule II drug, of course, but it's definitely something to be mindful of because that list can change. And the idea is that the rep must report payments or interactions for the list that is in effect, I'll say, at the time that the rep got his or her licensure or completed his or her renewal. So if your rep's just got licensed now or going through the process now, this is the list that will apply to them for the next year, okay? And I should mention, too, if you need a copy of this form, I'm happy to provide it. Just let me know. This form is an Excel spreadsheet, and the first tab of the spreadsheet is an instructions little list that mentions things like that. So there are some details that are helpful, I think, in that little instruction worksheet. Okay. The other thing here you see is the timeline. The timeline, I think, is particularly challenging. The idea is that the commissioner could say, we want reps to disclose the information that we've identified. The disclosure cannot be for more current than a month before. So I always think it's easier to think through this in an example, right? So if on, let's say, February 1st of 2018, the commissioner says that we want a disclosure, it could cover through essentially January 1st, right? So say they said we want it to be from November 1st of 2017 through December 31st of 2017, and it cannot be due more than or less than a month sooner. So if they requested it on February 1, it couldn't be due before March 1. But so that means that on March 1st, you might need to be able to disclose information as recent as January 1st. That's not a long timeline, right? So you essentially have as little as 2 months to get all of the data, clean it, verify it, create this wonky report that we have, and submit it to Chicago. So just a pretty quick timeline. And again, I don't anticipate that the volume of data will be huge because you're very limited geographically, but it will be a quick process for gathering the information and getting the report together and submitted. I'll mention, I don't think I said it already, that Chicago has said on the website that they won't ask for anything before January of 2018, and that we don't really have to collect information until, I think the website still says October 1st, but we've gotten confirmation that they won't ask for anything before October 15th. So you have some time, but still something certainly to be ready for, to get ready for. Okay. I know there's a lot there, and happy to answer questions, but I did want to let Ingrid spend some time talking about Nevada, which is on the horizon and another potentially fun requirement.
Yeah, and unlike Chicago, Nevada, which just passed in June, has not released any additional information or regulations or anything like that. But I think the requirements are quite interesting and something that we would love to take a look at. But before we get to the requirements, I want to talk about how this law came to be. This representative disclosure list law was part of a bigger bill that some of you may have heard of. It was a larger bill with a price disclosure component for certain diabetes drugs. And that bill was originally Senate Bill 265, which originated on March 14th, but was vetoed by the governor on June 2nd. The Pharmaceutical Disclosure Law, Representative Disclosure Law, was a part of that bill, and it was vetoed. Now, not because the governor did not like pharmaceutical representative license, this list, not because of that, but because of issues with the price disclosure bill, a portion of that bill. So the good old Senate decided that they were going to introduce another bill, Senate Bill 539, which included a revised price disclosure component, but then also had a nearly similar, a nearly identical pharmaceutical representative listing requirement. That bill the governor liked a lot better, and he approved it in ceremonial fashion on June 15, 2017. So this law is only about a month and a half old, so not many requirements or much guidance has been given. But there are a few things that we do know. We know that this law requires prescription drug manufacturers to provide a list of each pharmaceutical sales representative marketing prescription drugs on the manufacturer's behalf to licensed, certified, or registered healthcare providers, pharmacies, operators, employees of medical facilities. There's those medical facilities again. And so we know that there has to be that list. The interesting thing is, although this list only has to be updated at least annually, if your sales rep, if your pharmaceutical sales representative is not on this list, he or she may not market your drugs to any of the providers or residents in the state. So you have to be on that list, right? So if you get a new rep, you got to get them licensed, or they cannot speak to any of these. They cannot market your drugs in Nevada. The department must also provide that list for everyone to see on their website. So that is the list. And then if you happen to be included on this list, then you as a pharmaceutical representative have a disclosure requirement. Annually by March 1st, you must disclose a list of providers who you contacted, any compensation with a value that exceeds $10, total compensation with a value exceeding $100 in the aggregate, and the name and manufacturer of each prescription drug for which the pharmaceutical sales representative provided a free sample to a provider, and the name of each provider who received the sample. So if you're on the list, you have to disclose. You have to disclose some information. Now, again, this law just passed, so we don't have a lot of information, but the law did go into effect upon signing for the purpose of adopting regulations and performing administrative tasks. So we're just looking for the Department of Health to come up with some rules, right? And then the law is effective on October 1st, 2017 for all other purposes. So we are on the lookout.
We'll be here before we know it, right?
We'll be here before we know it. It's already August.
Okay.
Yeah.
So Nevada is tricky, right? Because there are some onerous-looking requirements there, but we don't have the insight yet, right? We don't have the detail. So right now, that's kind of the next one that we're waiting for, and we're hopeful that it won't be as scary as Chicago's, but we'll see. You know, we'll hopefully see pretty soon, because that October 1 date is around the corner. Right? So that is the extent of our presentation. I will say I am looking through our list of questions. Oops, sorry. And we have lots of them. So I'll try and answer a few, but I also wanted to give everybody a couple minutes back so that you have time before your next meetings, or if you have to have lunch, all that kind of stuff. So I will just pick a few, and like I said, if we don't answer your questions specifically, we will reach out to you directly, okay? Somebody said, can we get a copy of the presentation? Yes, absolutely. We're happy to send that out. Just let us know if you're interested. And obviously on the screen right now, you have our contact information. So feel free to reach out to us directly too. So somebody said, I think with respect to Chicago, it's my understanding that the reports were only for particular drugs, for covered drugs, and specifically right now for controlled substances. So right now, we're looking at just those Schedule II drugs. That's right. So the disclosure requirements would only be relevant if the interaction or a payment is in relation to a Schedule II product.
and also only on the request of the commissioner.
That's right. Someone else asked about that. So at this point, we only have to submit something if the commissioner says, please send us something,
Right.
which is different, right, from all of the other states and the federal requirements where we have a defined due date and a defined period, right? For all of them, it's the prior calendar year, whereas with Chicago, the timeline, the period for disclosure will be given to us at the time that the request is made.
Yep.
Someone asked, what is the definition of HCP in Chicago? It's pretty broad. It's a healthcare professional, and let me see if I have the actual language in front of me. Let's see. A healthcare professional is any physician or other healthcare practitioner who is licensed to provide healthcare services or to prescribe pharmaceutical or biological products. However, healthcare professional shall not include or shall not be interpreted to include healthcare practitioners who work exclusively with animals. So we're excluding vets, and you remember DC did that too, right? So specifically carved those out. And if you take a look at the Chicago report, the form that they'd like us to use, that field where you can identify, you give the name, the address, and some identifiers for the healthcare professional. One of those is a drop-down that allows you to put MD, DO, nurse practitioner, physician assistant, all of that kind of stuff. So you can see their list there. Okay. Let's see. Let me see again. Up a little bit to see other questions. Someone asked if these rules and laws apply only to pharmaceuticals. What about devices, lab tests, etc.? So we went through a lot today, so I'll be careful about how I answer. Chicago specifically is pharmaceuticals, right? So that's in the ordinance and in the definitions that it's specifically with respect to a pharmaceutical representative and pharmaceutical products. DC also is specific to pharmaceutical. The defined term is pharmaceutical detailer. The lobbying rules, I'll say, are much broader. Ingrid talked about the kinds of interactions and really the kinds of people that you might be interacting with that would trigger a registration and then potentially a reporting requirement. And some of those might be specific on the pharma side, but some of them are broader. Certainly when you're talking about having a hospital or a state put a procedure or put a product on its formulary or on its approved services list, things like that, that could certainly apply more broadly. Let's see. Someone asked about the definition of an HCP. Does it include nurses or only those with an NPI number, a National Provider Identifier? Again, that varies by requirement, right? So the DC rules, the Chicago rules, we're of course still hoping for more guidance from Nevada. So generally, we're talking healthcare professional more broadly than physician, right? So not just physicians, but either anyone who can prescribe or anyone who can make healthcare decisions or recommendations. Generally not limited to just folks who have an NPI. I don't think any of the states or the local requirements specifically say that the limitations or the restrictions are only for folks who have an NPI number, or that the reporting requirements only relate to folks who have an NPI number. Some of the report formats ask for an NPI number, but generally it's not a required field. So if your healthcare professional doesn't have one or you can't find one, our guidance is generally you should still report them unless you have reason to think that they are not licensed or not actually a healthcare professional. They're not, maybe your rep put it in their expense report incorrectly or something like that. Okay. Let's see. Someone asked, are the states listed in this presentation a complete account of all states that have pharmaceutical rep requirements? We won't say that. We think we're pretty all-encompassing, but particularly on the lobbying front, right? As we mentioned, most states and in fact many local government authorities have lobbying rules. Whether it has a licensure requirement or not, whether it has a disclosure requirement or not. Many of the governments do have lobbying requirements that talk about interacting with government officials, covered officials, things like that. Not all of them, in fact, many of them have not specifically talked about how they relate to pharma or the life sciences industry, but some of your companies may be looking at those more broadly, certainly from government, from governmental interactions, but also at the rep level, depending on the kinds of conversations and the kinds of folks that you're working with. To my knowledge, though, none of the other states have a licensure requirement or a disclosure requirement like DC or like Chicago now has. We're not aware of any other states that have that level of specific requirements for the pharmaceutical reps, the education requirements, the disclosure requirements, all that good stuff. All right. Someone asked for Miami-Dade. This is a great question. Miami-Dade says the Jackson Health System, not specifically the University of Miami. Are they connected? So it's a really good question, and Ingrid mentioned that there's an advisory opinion for Miami-Dade that really sort of ties the lobbyist requirements to our folks in the field, and that's where the University of Miami comes into play, because the question that was asked to the advisory opinion or to the advisory board specifically asks about interactions at the University of Miami. So there are a bunch of facilities as part of the Jackson Health System, certainly relevant, but also the University of Miami is tied in based on the guidance that the advisory board gave. Okay. All right, I'm going to stop there. We're just about out of time. Like I said, feel free to reach out to us for the presentation, for any other questions. We hope that you found the presentation today helpful. Unfortunately, we don't have all of the answers yet, but there's a lot of activity in this space, and so as it continues to evolve, we'll certainly try and stay on top of it and share it with you as we go. Like I mentioned, we hope to do additional webinars in the near future. So if there are topics that are particularly of interest to you, whether transparency related or not, let us know, and we'll certainly take them into account as we plan out our series. So thank you again. We hope you have a great afternoon. Bye-bye.